More than half the states in the union challenged Obamacare. Attorneys general from 26 different states argued that the individual mandate is unconstitutional, and today they lost, including Alan Wilson, the attorney general for the state of South Carolina. Mr. Attorney General, nice to meet you. Thanks for coming on. Is this just years of work just down the drain for you now with this ruling?
Well, Brooke, I don't believe so. Yes, it was a victory for the administration on a few legal points, but there was one victory that the states have, and the NFIB also has, is that we stopped Congress and the administration from redefining the authority and the power of Congress to extend well beyond the powers in the Commerce Clause. They tried to expand that power, and the court said, no, you're wrong. You can't do this under the Commerce Clause. Unfortunately, the court disagreed with the president in this way, but it gave him this authority under the tax. And now the president owns this tax going into the November election.
I want to play a little something you said on another cable network in March, right around the time of the oral arguments.
We had not called it a tax, 2 years ago.
Would you have challenged it?
Well, I would have challenged it politically, in the arena of Congress.
But not legally.
But legally, it would have been much more difficult for us.
You were talking tax a moment ago. You were talking tax then. The Supreme Court, as you now know, under the Article 1 of the Constitution, now says this is a tax. And by your own reasoning, we just heard, any further challenge to the law will be much more difficult, won't it?
Oh, absolutely. I mean, the Supreme Court has ruled. They claim it as a tax. Of course, I follow the dissent when I say I'm a bit perplexed, when I find it very remarkable, and Justice Kennedy highlighted this in his dissent, that it was not a tax for purposes of avoiding the Anti-Injunction Act prohibition, but it is a tax for purposes of enforcing the mandate. And another point that the dissent highlighted is that this took the ability to originate taxes in the House, and it gave it to the judiciary. The administration, the Congress, in passing this law, said over and over that this is not a tax. And then the court came back and said, no, it is a tax. And so I'm concerned about the precedent that this sets for future Congresses to be able to compel behavior by simply slapping a fee and calling it a tax.
As it is a tax, and it was sort of a tertiary argument, do you think the Democrats were cowardly for not presenting this as a tax from the get-go?
Well, you can call it what you want. At the time, it was not politically expedient. It was certainly not politically expedient. I'm not going to get into name calling, but what I am going to say is that the members of nobody in Congress was wrapping their arms around this being a tax 2 years ago, and no one, in fact, until this thing went to court, this was a penalty. When it went to court, it became expedient and convenient for it to become a tax for legal purposes. So it's only a tax when it meets the political need, when it meets the legal need, but it is not a tax when it has a political consequence. So they definitely were doing some gymnastics here and wordsmithing to avoid the label of it being a tax until it met their needs.
Are you saying the justices on the Supreme Court did the gymnastics here?
Well, I'm saying what the dissent in this decision said. I'm agreeing with Justice Kennedy and the three other justices when they said that it's remarkable when it's not a tax for the Anti-Injunction Act application, but it is a tax for purposes of the mandate.
Okay.
But the court has ruled. We're going to abide by that ruling.
I want to just look at your state here quickly. Insurance figures we pulled out for your state. 930,000 people in South Carolina, they don't have insurance. So that's, roughly 20% of your state's population, one of the highest rates in the country. Do you, Alan, find those figures embarrassing?
Well, listen, I'm obviously concerned about anybody that doesn't have access to affordable health care. But when you have a federal government that is trying to centralize control over something that is supposed to be in the free market system and claiming that anybody that stands in your way is against people getting affordable health care, I find that very disturbing. What you're going to have happen is you're going to have health care costs skyrocket for young, healthy Americans and more specifically South Carolinians. You're going to have Medicaid rolls expand with the inability of South Carolina and other states to be able to meet the needs of funding those requirements. So, I mean, I see a lot of problems coming in the future, and I see that number growing, and I'm very concerned about the number of people who are going to lose access to affordable health care. I mean, this is not going to have the effect that the president claims it has.
Alan Wilson talking to me from Columbia, South Carolina. Alan, thank you. At this
moment. Now to the Supreme Court's historic decision on the Affordable Care Law. Joining us is Congresswoman Nan Hayworth, member of the House Financial Services Committee, member of the House Doctors Caucus. She is the only female doctor voting member of Congress. Also joining us tonight, former Congressional Budget Office Director Douglas Holtzkin. and the Attorney General of the great state of South Carolina, Alan Wilson, who joined the Attorneys General of 25 other states in challenging Obamacare before the Supreme Court. Thank you all for being here. As the doctor in the House, if you will, Congresswoman, your first reaction to the Supreme Court decision today?
Lou, it does not change our mission at all, which is to free the American people from the burdens of this bad law. The 2010 health law was well intended. It has the right goals: good, affordable health care for all Americans, affordable, portable health insurance. But it is a bad law for us. It hurts rather than helps us. It imposes a $2 trillion bureaucracy on the American people. Those dollars need to go to care, especially to Medicare. $500 billion out of Medicare when it's already going bankrupt. Right. Our seniors, our working families, our taxpayers, our small businesses, all are unconscionably burdened by this act, and we need to repeal and replace it with a common sense plan that works for the American people and puts them at the center of health care.
Attorney General Wilson, your thoughts first on the fact that the writing, if you will, of the majority opinion, and secondly, its likely impact on your state.
Well, first, let me say this. The president and the members of Congress that supported this law shouldn't gloat too much, because I liken them to the dog that caught the car. They got their short-term victory today, but what they're going to have to explain over the next several months is how come 2 years ago, when they were trying to pass this law, not one single member of Congress that supported it called it a tax, because they didn't want to face the American people with a tax like this. And then when they went to court, the first thing they did is they ran with their lawyers to the argument that, oh, this is a tax now. And now the court basically went back, according to and rewrote the law to basically give the president and the administration what they wanted, give them a tax. He now owns the tax, but now he's got to explain to the American people why he basically duped them by passing this law, not calling it a tax to begin with, but now claiming it is a tax.
And the impact on the state of South Carolina and your position going forward on the affordability care law itself.
Well, listen, I've spoken to small business leaders and members of the NFIB today, as well as colleagues with the other attorneys general around the country, and we're all concerned for our states. I mean, obviously, some are claiming a narrow victory with the Medicaid expansion provision. I think it's going to be very harmful to the states in the long run. Members of the insurance industry and small business owners are telling me that they're not going to be able to comply with the onerous mandates and regulations that are coming their way. Many are going to have to cut corners, such as hiring people. Some insurance companies aren't going to be able to meet the mandates, and some of them are going to close down. I mean, this is going to cause health care costs to go up, and it's going to make it harder for working middle-class families to get access to affordable health care in the next 2 to 3 years.
Well, let's turn to the man who has a clear understanding of the national implications of this law, this decision. The former head of the Congressional Budget Office, Douglas Holtz-Haken. Doug, your thoughts first, your reaction to the decision.
Well, I think as a legal matter, I was quite amazed that it was possible to uphold the Constitution and say the mandate violated the Commerce Clause, and that the Medicaid expansions were a coercive use of federal power, and yet maintain the law. So here we are. This has now turned from a legal issue to a policy issue, and I would concur with what the Congresswoman said, that the American people are still waiting for the health care reform they need and deserve that provides high-quality care at low costs and affordable insurance options. This is not that, and we're going to have to move in that direction. Unfortunately, the one thing the court did went exactly the wrong direction. My reading of what they've done with the Medicaid expansions is they've given states the following choice. They can do a Medicaid expansion and bear some of the cost, or they cannot cost themselves a dime, and every one of those individuals would be eligible for subsidies in the federally subsidized exchanges. That shifts the cost from the states to the federal government. My expectation is this is going to be raising the price tag of this act by hundreds of billions of dollars.
It does, and it seems to me that you've identified a significant trap within this decision for the federal government here. And that is the majority deciding that they could not, that the federal government, the Obama administration, could not, nor could Congress, limit federal aid, which was to be the coercive response to a waiver or withdrawing from affordable care, it looks like they can stand pat to no effect, to no disadvantage of the state.
It's in fact a little bit stronger than that, because in 2014, not only could a governor or a state stand pat, they could actually roll back their Medicaid if they've expanded it all to the bare minimum required by the federal government, and anyone who they were paying 40 cents on the dollar for will be shifted over again to the federal subsidies. The state won't pay anything. The taxpayer will be at risk for not just their costs, but in fact more costs, because those insurance packages are richer and much more costly. So this was a law which had great financial risk for the nation to begin with. There was always the chance that employers would choose to dump their employees into the exchanges. Now we have an opportunity for states to dump their Medicaid programs into the exchanges. The ultimate price tag, I think, is quite high.
Congresswoman Hayworth, you as part of the Republican leadership, the House has voted, it seems like dozens of times, on repealing Obamacare. Another vote has now been scheduled for, what is it, the 11th of next month. To what end?
July 11th. Mm-hmm.
To what end?
Well, Lou, we were elected on the pledge that we would repeal and replace that law. We did have a vote in the House in January of 2011, and it was not a symbolic vote. That was the real will of the American people being expressed through us. Survey after survey has shown that the American people have not grown any fonder of this bad law in these ensuing months. So we're going to have another vote, and we are going to hope that this time the Senate will come along with us, because the American public has made its disapproval clear.
All right, Congresswoman. Douglas Holtz-Eakin, we thank you for being with us. Attorney General Wilson, as always, good to talk with you. Thank you so much. Up next, Wall Street